Judicial review is firmly rooted in India. The Constitution of India explicitly establishes the doctrine of judicial review in its various provisions like Articles 13, 32, 131 to 136, 143, 226 and 246. Judicial review has been declared to be the basic structure of Constitution. Article 13, Section 2 even goes to the extent of saying that the state shall not make any provision which takes away or abridges the rights conferred by Part 3, Fundamental Rights of the Constitution, and any law made in contravention of this clause shall, to the extent of contravention, be void. Supreme Court in State of Madras vs. Roe, AIR 1952 SC, observed that the Constitution contains express provisions for judicial review of legislation and to its conformity with the Constitution, and that the courts face up to such important and none too easy task not out of any desire to tilt at legislative authority in a crusader spirit, but in discharge of a duty plainly laid upon them by the Constitution. While the Constitution naturally attaches great weight to the legislative judgment, it cannot desert its own duty to determine finally the constitutionality of an impugned statute. The doctrine of supremacy of Constitution and judicial review has been expounded very lucidly but forcefully by Justice Bhagwati in the case of State of Rajasthan vs. Union of India, AIR 1977 SC. It is necessary to assert in the clearest terms, particularly in the context of recent history, that the Constitution is supreme lex, the permanent law of the land, and there is no department or branch of the government above or beyond it. Every organ of the government, be it executive or the legislature or judiciary, derives its authority from the Constitution. No one, however highly placed, and no authority, howsoever lofty, can claim that it shall be the sole judge of the extent of its powers under the Constitution, or whether its action is within the confines of such power laid down by the Constitution. This court is the ultimate interpreter of the Constitution, and to this court is assigned the delicate task of determining what is the power conferred on each branch of government, whether it is limited, and if so, what the limits are, and whether any action of that branch transgresses such limits. Therefore, the courts in India cannot be accused of usurping the functions of constitutional adjudication. It is a function which has been imposed on them by the Constitution itself. It is a delicate task. The courts may even find it embarrassing at times to discharge it, but they cannot shirk their responsibilities.